Imagine for a moment the whole process of buying or selling property. For so many people, it just means mountains of paperwork, right? Endless signatures. And a timeline that feels, well, kind of stuck in another century. It can be a real headache. Stressful, worrying about security, accuracy. But what if all that changed? What if that whole labyrinthine journey could become totally digital and incredibly secure, beautifully streamlined, not just an idea, but actual law? Welcome to the deep dive. Today, we're pulling back the curtain on a piece of legislation that promises exactly that. The Electronic Deeds Registration and Recordal Systems Act 19 of 2019. Our mission? Well, it's to take you through this act, explain its purpose, its game-changing parts, the legal world it fits into, and what it really means for everyone, whether you're just curious or maybe a law student deep in property law. And this isn't some dusty old law either. It's very current, very much alive. It's seen significant updates, actually, as recently as September 1, 2025. So we'll be digging into that, too. Get ready for some real insights. Okay, let's unpack this then.
At its core, what problem is this act trying to fix? What's the fundamental goal?
Well, it's really tackling a system that's kind of groaning under its own weight, A paper-based system that, okay, it worked historically, but it's slow. It's vulnerable to physical loss, fires, floods, and just, well, human error. This act is a very deliberate, a foundational shift. It's moving property transactions from all that physical paper into a secure digital environment. Its official long title, which interestingly was updated very recently to really sharpen this modern focus, says it's to provide for electronic deeds registration and recordal, having regard to legislation regulating electronic communication and transactions, and to provide for matters connected therewith. So basically, it's about dragging property ownership into the digital age, making sure it aligns with South Africa's wider laws on, well, everything online.
Okay, so it's not just about making things easier then. It sounds like more than just convenience. What does this digital leap really mean for you, the listener, if you're buying a house or land?
Exactly. It's much more than convenience. For you, the buyer or seller, it promises, first off, increased efficiency. We're talking potentially speeding up transfers, maybe from months down to weeks. That's a huge difference. And crucially, it boosts security, big time. Replacing those paper records, which can be forged or lost, with encrypted digital ones, that makes fraud much, much harder. And it also aims for greater accessibility. Many processes could eventually be handled remotely. So yeah, it's not just admin. It's about building more trust and speed into one of life's biggest financial moments.
Wow, yeah. That really does sound like a dream for anyone who's navigated that process before. But okay, how does this digital vision actually get built and managed? What are the sort of nuts and bolts that make it all work?
Right, that's where Section 2 of the Act really comes into play. It focuses on the development, establishment, and maintenance of this whole system, and it puts that massive task squarely on the shoulders of the Chief Registrar of Deeds.
The Chief Registrar. Okay, so they're the main person in charge.
Exactly. Think of them as the ultimate guardian, the architect, really, of all property records in the country. The Act mandates them to develop, establish, and maintain the electronic deeds registration and recordal system. And they have to do this using information and communications technologies, modern tech. It covers absolutely everything from how documents are prepared digitally to how they're lodged, registered, and finally stored, making it all digital ready.
So the chief registrar is the master builder here. What kind of authority do they have to make sure this system is actually, robust and secure?
Oh, quite extensive authority. And rightly so, given what's at stake. Section 2 empowers the chief registrar to issue crucial directives. And these aren't just like suggestions, they're the actual rules of the road. They define the system's functional needs, the technical specs, how it connects with, say, banks or law firms. They also set really strict information security standards. They guide how digital deeds are processed, how records are kept, how they're produced if needed. It's comprehensive.
So they're essentially building a digital fortress around our property information. What's the main takeaway for you, our listener, from all this infrastructure talk?
The takeaway is huge, actually. It means a really solid, secure, clearly defined digital system is being built piece by painstaking piece. These directives mean that when you eventually use this system, buying or selling, you can trust it. You can trust that it's not just efficient, but also reliable, legally sound, and protected by top-tier digital standards.
Right. Now, in the old paper world, we get what an original deed is. It's that physical paper, the wet ink signature. But when everything goes digital, what actually counts as the original, the legally valid record? This is where it gets super interesting for legal certainty, I imagine.
It's a total paradigm shift, absolutely.
Yeah.
And Section 3 is critical here. The Act states very clearly that an electronic deed or document, So one that's generated electronically, registered electronically, executed electronically, or even just a scanned image of an old paper original that gets pulled into the system. That digital version is for all purposes deemed to be the only original and valid record.
Wow. Okay. The only original.
Yes, it's a profound change. It means your digital deed, once it's recorded in the system, has the same legal standing, arguably even greater, more unquestionable standing than any paper deed ever did.
So no more fighting over which photocopy or version is the real one. That sounds like a massive step forward.
Precisely. That clarity is just vital for legal certainty. And it also operates subject to Section 14 of the Electronic Communications and Transactions Act, the ECTA, which, for anyone less familiar, is basically the big overarching law in South Africa that governs the validity of all electronic transactions and data. So this Deeds Act fits perfectly into that wider digital legal framework. It's all integrated. It ensures that the digital original isn't just a convenient copy. It is the single source of truth for your property ownership.
Okay, with a system this secure, this legally binding, who actually gets to use it? Is it just open for anyone to log into, or is access tightly controlled?
Oh, access is very much controlled, and that's absolutely critical for security and integrity. Section 4, which deals with authorized users, is very specific. It says any user authorized by the regulations must be registered in the manner and under the conditions as may be directed by the Chief Registrar of Deeds. So it's definitely not a free-for-all. Think of it more like a gated community for trusted professionals.
And why is that controlled access so important for you, the property owner?
It's fundamental, really, for both security and accountability. By demanding specific authorization and registration, the Act makes sure only legitimate, verified parties can interact with that sensitive property data.
Like your conveyancer, for instance.
Exactly, like your conveyancer or maybe bank officials involved in a bond. This drastically cuts down the risk of someone unauthorized getting in or any kind of malicious activity. It's just another vital layer protecting your most valuable assets.
Makes sense. Now, a system this complex, dealing with such critical assets, it must need a really detailed operating manual, right? An operational blueprint. Let's talk about the regulations and maybe some of the key definitions that hold it all together. Who actually writes these rules? And what sort of things do they cover?
Right. The power to make these regulations sits with the minister. Specifically, it's the Minister of Agriculture, Land Reform, and Rural Development, the department handling land matters. But importantly, this isn't done in isolation. The minister acts on the recommendation of the Regulations Board, and that board is a key body established under the existing Deeds Registries Act. So there's continuity there. These regulations are essentially the day-to-day instruction manual for how the system actually works on the ground.
Okay, and what kind of procedures are we talking about? What do they actually define?
They're incredibly detailed. They cover everything from the step-by-step process for lodging deeds electronically to exactly how the deeds registries will securely store all these electronic records. They define how people like your conveyancer or a notary public, those legal experts handling transfers and verifying documents, how they'll be identified digitally when they prepare or execute a deed. Authentication is key. They also cover things like how you pay fees electronically and even how the public can access certain information from the system just for looking things up.
Sounds like they're trying to think another thing. And I'm really interested in the public's role. Do people get a chance to have their say on these crucial rules?
Absolutely. And that's a really important democratic check. Before any regulations become final, the minister must publish the proposed drafts in the Gazette.
The Gazette being the official government publication for notices and laws.
Exactly. And there has to be a period of at least 30 days for public comments. And the minister is legally required to consider those comments. So the system, which affects everyone, isn't just designed behind closed doors. It actually benefits from real-world feedback that strengthens its legitimacy and, frankly, its practical usefulness.
Right. So the regulations are the how-to guide. But to really get the act, some of the words they use, they need translating from legalese, don't they?
Yeah.
It's not just jargon. It clarifies what exactly is being digitized.
You're spot on. Definitions are the absolute bedrock. Take deed or document, for example. It's not just paper anymore. The Act defines it as a data message, which basically is just any information sent or stored digitally. Think email, a Word doc, that kind of thing, as defined in the ECTA. And, crucially, the definition says it includes scanned images of a deed or document.
Ah, so existing paper records can be brought into the digital system smoothly?
Precisely. It allows for that transition.
And what about signatures? We're not just talking about a fancy font that looks like a signature, are we?
Not at all, no. For the key professionals, conveyancers, notaries, registrars themselves, a signature under this act specifically means an advanced electronic signature. That's also defined in the ECTA. And it's not just a picture of a signature. It's a highly secure, legally recognized digital fingerprint, if you like, unique to that person. It uses cryptography, complex coding to verify the signer's identity and to ensure the document hasn't been tampered with since it was signed.
Okay, that sounds way more secure than just scribbling on paper.
It offers a much, much higher level of security and non-repudiation than a traditional wet ink signature. It really does. The Act also clearly defines terms like authorized user, who we talked about, someone registered to use the system, and it links terms like conveyancer, registrar, and deeds registry back to the existing Deeds Registries Act. So it weaves everything together into one coherent legal picture.
That detail about the advanced electronic signature really underlines the security aspect. So thinking about the bigger picture,
Yeah.
how does all this affect the current way of doing things, the manual system? How does South Africa actually make this huge shift from centuries of paper to a fully digital system without causing, total chaos or uncertainty in property deals?
Yeah, that's a critical question, and the Act anticipates it very carefully with its transitional provisions in Section 6. They're designed precisely for a smooth, managed shift. First off, it explicitly states the Act does not affect the validity of any registrations and recordals affected prior to the coming into operation thereof.
Whew. Okay, so all past deals are safe. Your existing title deed is still 100% valid.
Absolutely. Complete continuity, no retroactive problems. That provides essential stability.
That's a huge relief, I'm sure, for everyone who already owns property.
Yeah.
But how gradual is the actual switch? Does the old paper system just stop dead one day?
No, not at all. It's designed as a carefully phased approach. The registrar, conveyancers, notaries, they'll all continue with the registration, recordal, execution, and filing of deeds and documents as prescribed by the Deeds Registries Act and the Sectional Titles Act, until the electronic deeds registration and recordal system or related provisions or regulations are in place. So, only when the digital alternative is fully ready and operational will the old manual procedure start to be discontinued. And what's really interesting is the flexibility built in. The chief registrar can issue directives allowing for a hybrid system for a set period.
A hybrid system, meaning?
Meaning conveyancers and notaries could actually choose whether to use the manual system or the new electronic one for a time.
Ah, okay. That sounds like a very pragmatic way to manage such a massive change during the transition.
It allows people to adapt, systems to be tested thoroughly in parallel.
And what about the legal status of things done digitally during that switchover period?
The Act covers that directly too. It says, an electronically executed or registered deed shall be deemed to have been executed or registered in the presence of the registrar by the owner or by a conveyancer authorized by power of attorney, unquote. So those digital actions carry the full legal weight, the full authority, as if they happen physically in the registrar's office. It ensures legal certainty right through the evolution of the system. This whole phased rollout is just meticulously designed to keep things stable, keep things legally sound, and avoid any disruptive shocks.
Right. And as you said, this isn't just some far-off dream. It's actually happening now, step by step. Let's quickly touch on the timeline for this huge transformation. The Act got the nod back in September 2019, probably soon after. But the rollout itself has been quite deliberate, quite staggered, hasn't it?
Indeed it has. Very phased. It kicked off with the foundational work developing the actual system. That's Section 2 commencing way back in December 2019. That allowed time for the digital infrastructure to actually be built. Then, more recently, by December 2024, the rules around who can use the system and how Sections 4 and 5 on authorized users and regulations came into effect. That paved the way for the system to actually start being used properly. And then, as of April 1st, 2025, some really core legal parts were activated. We're talking the definitions, the rules on validity of electronic deeds, those crucial transitional provisions, Sections 1, 3, and 6.
So the legal framework is largely in place now.
Much of it, yes. Although the final full activation switch covered by Section 7 is still technically to be proclaimed by the president. But it's clear we're well into deep implementation territory. And it's also really important to remember, as you mentioned earlier, that parts of this act, like the titles and some definitions, were themselves updated by another act, Act 20 of 2024, with effect from September 1st, 2025.
So it really is a living, evolving piece of law, constantly being fine-tuned.
Exactly. It shows it's actively responding to needs and refinements as the rollout progresses.
So we're definitely in the thick of this transition. What's the real-world significance, the practical impact of this phased rollout for you, our listener?
Well, for the general public, I mean, it genuinely promises faster, definitely more secure, and hopefully more transparent property transactions. That's the end goal. The required use of things like advanced electronic signatures, for instance, it just slams the door on a lot of traditional paper-based fraud. It introduces a whole new level of digital trust. For the legal pros, conveyancers, notaries, it's obviously a fundamental shift in how they work. A huge change. It means adapting to completely new digital workflows, learning new systems. But the payoff should be much greater efficiency, potentially saving enormous amounts of time and resources that used to go into shuffling paper. And looking bigger picture, economically, this is a major modernization for a critical sector of the economy. It should improve the ease of doing business in South Africa, maybe even help attract investment. So yeah, this act isn't just some administrative tweak. It's really a foundational step. It's bringing property ownership squarely into the digital age, impacting millions, and setting a new standard for how national infrastructure can work.
And what a fascinating journey it's been, really digging into the Electronic Deeds Registration and Recordal Systems Act 19 of 2019. It's so clear this is truly forward-thinking legislation, designed to bring property registration kicking and screaming into the 21st century, and probably beyond.
Absolutely. And as we see South Africa digitize such a fundamental legal process, maybe a final thought for you, the listener, to consider is, what broader questions does this whole process raise? Questions about the future of traditional legal practices everywhere, not just here, about the absolute need to ensure everyone has access to these digital systems, digital inclusion, and maybe even how the South African model, as it develops, might influence other countries facing similar challenges in updating their own property laws. It's definitely a conversation that's only just getting started.
Some really thought-provoking questions there. Thank you for joining us on this deep dive. We really hope you feel a little more clued in and maybe quite a bit more intrigued by this digital revolution happening right now in property law.